The President, please be seated. The court is now in session. During this morning's session, the Chamber proceeds the case 002 while pronouncing the oral decision and another decision. The purpose of today's hearing is indeed for the trial chamber to announce its disposition of its decision on the accused Nuon Chea fitness to stand trial. After the chamber has conducted the hearing to hear the testimonies of two experts, Professor John Campbell and Sina Fazel, on the 25th of March 2013. The two experts have been reappointed to assess or review the health and fitness to stand trial of Mr. Nuon Chea. And another issue here is of the severance of the proceedings in the light of the Supreme Court Chamber's decision of the 8th of February 2013. The Chamber today also announces the resumption of the proceedings in case 002 in order to safeguard the rights of all accused to a fair, expeditious trial and the interest of justice in reaching a timely verdict in this trial. Court officer is now instructed to report to the chamber the current status of the parties to the proceedings. Rather, the greffier is now instructed to report on this. The greffier: Mr. President and Your Honors, all parties to the proceedings are present except Mr. Nuon Chea, who is absent due to his health concerns. Mr. Nuon Chea has waived his right to be present in today's hearing. Mr. Jacques Vergès, counsel for Mr. Khieu Samphan, is absent due to his personal commitment. The President, thank you, Ms. Sakovati. Next, the Chamber would like to announce its deposition of its decision as follows. Notwithstanding the advanced age and frailty of the accused Nuon Chea and the accused's precarious physical health, the recent report and testimony of the court-appointed medical experts clearly indicate that the accused remains capable of meaningful participation in his own defense. On the basis of the conclusions of the medical experts, the trial chamber therefore affirms its earlier finding that the accused Nuon Chea is fit to stand trial. The trial chamber's written decision in this regard will follow as soon as possible. Trial chamber now issues its deposition of its decision on severance of case 002/01. following Supreme Court Chamber decision of the 8th of February 2013. The Chamber's recent written decision on this matter will also follow as soon as possible. On the 8th of February 2013, the Supreme Court Chamber rendered its decision on the co-prosecutor's immediate appeal of the trial chamber's decision concerning the scope of case 002/01. In its severance order of the 22nd of September 2011, the trial chamber, in the interests of achieving a timely verdict in case 002, had limited the scope of the first trial in case 002 principally to forced evacuations, later extending it also to executions carried out at Tuol Po Chri. The Supreme Court Chamber decision annulled the trial chamber's severance order and related decisions. Although the Supreme Court Chamber decision envisaged the possibility of a fresh severance of case 002, the immediate consequence of the Supreme Court Chamber decision was that case 002 was no longer confined in scope and the trial chamber unable to proceed to any verdict in this case until all factual allegations and charges contained in the case 002 closing order are adjudicated. In annulling the severance of case 002, the Supreme Court Chamber considered the trial chamber to have erred in its interpretation of the scope of its discretion to order severance pursuant to Internal Rule 89 ter. In failing to hear the parties prior to the issuance of its severance order and for having, among other factors, given inadequate consideration to the need to ensure that the charges retained in case file 002/01 are sufficiently representative. In order to minimize further delay to proceedings in case 002, on the 12th of February 2013, the trial chamber scheduled hearings on the issue of severance, outlining a number of issues for the parties to address in the light of the Supreme Court Chamber decision. Following these hearings on the 18th, 20th, and 21st of February 2013, in court examination of the court-appointed medical experts who reassessed the fitness to stand trial of the accused Nguyen Chia on the 25th of March 2013, and having weighed the factors identified in the Supreme Court Chamber decision and the impact of the death of Ieng Sari, the Chamber issues its present decision. For the reasons that will be outlined in its written decision, the trial chamber decides to sever case 002 pursuant to Internal Rule 89 ter by confining the scope of case 002/01 to the charges related to forced movement of population phases 1 and 2 and executions at Tuolpo Chirei. These are the brief oral decisions by the trial chamber. The chamber has no other issue to raise during this morning. So the chamber will adjourn this hearing as of now, and the proceedings regarding case file 002 will be resumed on Monday next week, rather on the 8th of April 2013. During the week commencing 8th of April 2013, the trial chamber intends to conclude the testimony of TCW 100, followed by the examination of TCW 536. The co-prosecutors have already been given the time to put questions to one of the witnesses, and it is now time for the lead co-lawyers to proceed with the questioning of the party of the witness, and lead co-lawyers will have one session for that, which is equivalent to 1/4 of the given time for putting the question to the witness. Regarding TCW 100, his testimony was partly heard during the session on January 2013. His next testimony was scheduled on the 14th of January 2013. Nonetheless, due to the medical condition of Mr. Nguyen Chie, who had to be admitted to the hospital on that occasion, the chamber could not hear the complete testimony of TCW 100. So the questions were put by the prosecutors to the witness, but other parties were not yet given the opportunity to do so due to the outlined condition. And after TCW 100, there will be the examination of TCW 536. Schedule to hear the testimony of this witness was set, but due to the health concerns of the accused, the chamber could not hear this witness' testimony. The chamber now plans to hear the testimony of TCW 536 before the Khmer New Year. The trial chamber will hear these witnesses for 2 days and a half. Questions to be put by the judges of the bench, then followed by parties to the proceedings. The Chamber wishes to inform the parties to the proceedings that the Chamber will do its best to make sure that the proceedings are conducted in case 002/01 as scheduled and the following hearings, unless the Chamber is faced by other challenges, including the availability of essential Cambodian staff who may not show up at work, or perhaps due to budget shortfalls or other relevant issues. The Chamber will notify the parties as well concerning the scheduling of the hearing by the first week of April. I now would like to hand over to Judge Silver Cartwright to continue informing the public and the parties of the proceeding if she would wish to do so.
Yes, thank you, President. The trial chamber has scheduled the resumption of hearing of the evidence for the 8th of April, given that as of last night, it was very unclear whether essential Cambodian staff would be available next week. The coordinator of UNICART has just this morning informed the international judges that funding for the national staff has been secured through to the end of April, and that ongoing discussions are underway to stabilise funding from that point on. It is unfortunately too late for us to schedule any witnesses for next week for a variety of reasons, and we therefore prefer to stay with the schedule indicated to the parties yesterday, which is 8th of April, as the President has indicated. President, I think you wanted to say some other comments about schedules of witnesses and experts from the parties, or would you prefer me to mention that issue? Yes, the final matter that the trial chamber wanted to communicate to the parties is this. The chamber will seek further submissions from the parties concerning witnesses and experts to be heard in the weeks following the 8th of April, should it consider this is required to enable it to discharge its trial management functions. Pending any such request by the trial chamber, the parties should not file further suggested witness and expert lists or proposed schedules for the ongoing hearing in case 002/001. President, I think that covers all the issues that were required for this morning.
The President, thank you. Judge Labian, you may now proceed.
I just want to make a little clarification for French speakers. The chamber is asking the parties not to make any submissions regarding expert witnesses. It will do so if it deems it necessary subsequently.
The President, thank you, Judge Lavan. The Chamber would like to adjourn the hearing now, and the next session will be resumed on Monday, the 8th of April 2013, commencing at 9 a.m. Security personnel are now instructed to bring Mr. Kilsampon back to the detention facility and have both accused persons return to the courtroom by Monday, the 8th of April 2013, before 9 a.m. The court is adjourned.
សូមក្រោកឈរ